The broadcast is now starting. All attendees are in listen-only mode.
Good morning or good afternoon, depending on your time zone. Welcome to the webinar on the Introduction to the Protection and Advocacy Programs being hosted by the APS Technical Assistance Resource Center in conjunction with NAPSA. This is Lori Delagrammaticus. I'm going to be hosting today. I'm going to first let Andy Capehart from the APS TARC walk us through a couple introductory slides, and then we'll introduce our presenters. Andy?
Thank you, Lori. Hi, everybody. My name is Andy Capehart. As Lori said, I'm with WRMA and the APS Technical Assistance Resource Center. Just a quick disclaimer before we get started. The Adult Protective Services Technical Assistance Resource Center is a project of the U.S. Administration for Community Living, Administration on Aging, Department of Health and Human Services, administered by WRMA Incorporated. Contractors' findings, conclusions, and points of view do not necessarily represent those of the federal government for any of these intro comments. And just a quick note about our APS Technical Assistance Resource Center. We're here to help APS programs in any way that we can. Just reach out to us at any time. We'll have some contact information that will be displayed at the end of this webinar, and also our website where you can check out all of the things that we do. But if you work for an Adult Protective Services program and you would like some technical assistance, reach out to us. We would be happy to help you in any way that we can. A bit of housekeeping before we get started. This session is being recorded. It will be posted to the web at a later date. We'll make sure that we notify all the people who signed up for this webinar via email when it is posted online. You can use your telephone or your computer to connect to audio. Just select the option that you prefer on your GoToWebinar control panel. We have an example here where it's circled in purple, where you can make that selection and use your phone or your computer. All participants are muted for this webinar, so there's no need to mute your line manually. And if you have questions of our presenter, you can type those questions in the question box. An example of where to type those questions is circled here in purple on the slide. You don't have to wait until we pause for questions to submit yours. You can type them at any time, and we'll relay them to our speakers when it's time for questions. So again, if a question occurs to you as we move along, you can type it in at any time, and then when it's time for Q&A, we'll get to your questions then. So what we'd like to do now is administer a quick poll and see what the makeup of our audience is. I'm going to launch this poll right now. It will pop up on your screen, and basically you can just click on the answer that corresponds to your profession. And the question, of course, is which of the following categories do you identify the most with, whether you're an adult protective services professional, other social services professional, medical, legal, or other. It looks like folks are responding to that right now, so we'll give it just a few more seconds to give a chance for people to vote. And again, you can just click right on your screen and select the option that fits best for you. Keep it open just a little bit longer, and then we'll display the responses for everybody so that everybody can check out who is on the call with us. About 5 more seconds. And I'm going to close that poll out now and then share the results with everybody so you can take a look at what the makeup is. Looks like a little over half of you are adult protective services professionals, followed by people who consider themselves other. And then we have other social services professionals, legal professionals, and then about 2% of you are medical professionals. So that is the makeup of our audience today. Thanks for responding to that poll. And now I will turn things back over to Lori Delagrammaticus. Lori, you have the floor.
Thank you. I don't usually read the bios of our speakers, but given that half of our audience is from APS and may not be familiar with the Administration for Intellectual and Developmental Disabilities and how that fits into the Administration for Community Living, I thought I'd run through where Jennifer and Ophelia fit into that structure. So Dr. Jennifer Johnson is the Deputy Director of the Administration on Intellectual and Developmental Disabilities at the Administration on Disabilities at the Administration for Community Living, which is part of the U.S. Department of Health and Human Services. In this capacity, she provides overall leadership of the ACL programs and activities related to persons with intellectual and developmental disabilities, including the Developmental Disabilities Assistance and Bill of Rights Act, and the President's Committee for People with Intellectual Disabilities. So that gives you an idea of where she fits into things. Before joining AIDD, Jennifer held a position at the Arlington County Public School System, at the County for Exceptional Children, and at the George Washington University, where she's also an adjunct lecturer teaching master's level coursework on research methodology, special education, and public policy. And her doctorate is from the George Washington University. So some really good credentials going on there. And our second presenter today is Dr. Ophelia McLain, who has been with HHS since January of 2003. She's the director of the Office of Program Support within AIDD, and she oversees 56 state councils on developmental disabilities, 57 protection and advocacy systems, and 67 university centers of excellence in developmental disabilities, and all of those were authorized by the Developmental Disabilities Assistance and Bill of Rights Act of 2000. She also oversees the protection and advocacy programs under the Help America Vote Act, the Assistive Technology Act, and the Traumatic Brain Injury Program. She previously served as the director of the Office of Innovations at AIDD. In addition, she participates in collaborative efforts with other federal partners, such as the Department of Education, Department of Labor, and Social Security Administration. She's an Excellence in Government Senior Fellow and holds a Doctor of Health Administration degree and an International Health Certificate from Central Michigan University, and a Key Executive Leadership Certificate from the American University. So wonderful credentials there as well. I hope that gives those of you in APS sort of a picture of where they sit within the Administration for Community Living. And with that, I will hand it over to Jennifer and Ophelia to do our presentation today. Thank you guys for being willing to do this.
Well, thank you for that introduction. This is Jennifer Johnson with the Administration for Community Living. We want to thank you for joining us today for this webinar. We're really looking forward to having the opportunity to share information about the protection and advocacy programs that we fund here at ACL. We also wanted to thank the APS, TARC, and NAPSA for inviting us to speak today. We have, over the years, talked about collaboration with the Adult Protective Services System, particularly with our protection and advocacy programs. And we see this as really a great opportunity to work more together in support of ensuring people with intellectual and developmental disabilities are protected from abuse and neglect. We know that there is collaboration that goes on out in the states between the Adult Protective Services Systems and our protection and advocacy systems. But we again want to support that work and build upon that to ensure people are protected. I wanted to mention, Ophelia was also introduced as one of our speakers here today. She will also be at the NAPSA conference in a couple of weeks doing some presentations there. So we're excited that she'll have the opportunity to be there in person at the conference and share information there and present along with our colleagues here in ACL. Today we're going to give you a broad overview of our work within the Administration on Disabilities and more specifically on the P&A program, but that again will be an overview of the P&A program. We hope to continue this dialogue and share additional information in the future about the protection and advocacy programs and our collaboration with Adult Protective Services. Lori did give some information about where we sit within the Administration for Community Living, and I imagine that many of you are familiar with the Administration on Aging. We are the center in ACL that is the component of ACL that deals with disability programs. So the Administration on Disabilities administers a number of disability-related programs that include those that are funded under the Developmental Disabilities Assistance and Bill of Rights Act, which were mentioned in our bios. Those include the state councils on developmental disabilities, the University Centers for Excellence in Developmental Disabilities, what's called Projects of National Significance, and then again the protection and advocacy programs that we're going to talk about today. And as far as the state councils go, they are in every state and territory, along with our University Center grants are in every state and territory. Our projects of national significance are more of a discretionary grant program that address national needs, and so those are more targeted resources that we have, some of which are focusing on the issue of health and safety of individuals with intellectual and developmental disabilities and how we do monitoring of that. All of our work within the Administration on Disabilities is in line with the mission for the Administration for Community Living in terms of ensuring older adults and people with disabilities have quality community living experiences. Our programs obviously focus more on the population of people with intellectual and developmental disabilities, but within AOD we have other programs that address other specific areas of disability such as traumatic brain injury or paralysis or limb loss, or those some of those different types of disabilities. I'm going to, like I said, this presentation today is going to be a broad overview of our work and the P&A program, but one of the things I wanted to start out with is why the P&A system was created and why there was a need for a P&A system. And this really started back in the 70s. When there was an expose that Geraldo Rivera did of an institution in New York called Willowbrook, where he brought to the public scenes from inside this institution and the horrid conditions in which people were living. We can't show you the YouTube video on the webinar today, but we have this link that if you're interested in seeing the story that was featured back in the 70s that led to the creation of the P&As, you can do so by following this link that's on this slide. Like I said, he really brought to the forefront the horrid conditions in which people with intellectual and developmental disabilities were living in the state institution. There were some other exposés going on at the same time. Another prominent one was in Pennhurst in Pennsylvania. And so there was awareness that we needed to do better, and we needed to ensure people with intellectual and developmental disabilities had access to a legal advocacy system that would ensure the protection of their rights and ensure that they're protected from abuse and neglect. And so that was really the impetus for creating the P&A system, and that remains the focus of the P&A system today, even though over the years it has diversified and it works in multiple areas. Still critical to the work of the P&A is ensuring people are protected from abuse and neglect and have their rights protected. The P&A systems were created in 1975, and they were a program that was added to what was the Developmental Disabilities Assistance Bill of Rights Act at that point in time. The act originated by the creation of the University Centers programs that we have today, and that was back in the 1960s. And then in the early 70s, the state councils were added, and then the Protection and Advocacy Systems was the third entity added to the DD Act, as we call it. So the DD Act and the DD programs really have a very long history in the disability movement, and the history is really embedded in the idea of people living quality lives in the community. So that's just a brief overview of our programs and a little bit of the history behind it. And I'm going to turn it over now to Ophelia, who's going to take you through more information about the P&A program.
We thank you all for simply attending to understand a little bit more about our P&As. And like Jennifer mentioned, this PowerPoint is really to introduce you to what the P&As are required to do. And we will hopefully delve into how you can collaborate with the P&As. And please forgive me for repeating anything that some of you may know about the P&As, erring on the side of caution that not all do. And we are going to go ahead and get a little bit more into what we do, who we are. So there are 7 P&A programs, 4 of which are housed at the Administration for Community Living. And these cover the Protection and Advocacy for Developmental Disabilities, which we refer to as the PAD program, the Protection and Advocacy for Assistive Technology, which is the PAT system, the Protection and Advocacy for Traumatic Brain Injury, which is PAT-B, and the Protection and Advocacy for Voting Access, which we refer to as PAVA. There are three other programs that are housed at SAMHSA within the U.S. Department of Health and Human Services, the RSA, which is at the Department of Education, and also the Social Security Administration. There are some P&As, just a few, that administer the Client Assistance Program, which is we refer to as the CAP. So Jennifer mentioned that there is a P&A in every state and territory. Plus, we have one which is the Native American P&A, and it is actually situated in New Mexico, but it relates to all of the four corners, what is referred to as the four corners in that area. So Jennifer mentioned the Developmental Disabilities Assistance and Bill of Rights Act. The most recent that was reauthorized was 2000, and we simply say the DD Act. Much of the context for this presentation will come from the DD Act and not go into in-depth into the other legislation because this is where the P&A started. The purpose of the DD Act is to assure that individuals with developmental disabilities and their families participate in the design of and have access to needed community services, individualized support, and other forms of assistance that promote self-determination, independence, productivity, integration, and inclusion in all facets of community life. And the next slide simply goes into detail on what the facets of the DD Act are. The PAD program assists individuals with DD who have been neglected or abused, denied access to a service, denied control or choice of a service to which they have a right, and they are also those that are denied the opportunity to participate in an activity. You will notice that the P&As do some of what the APS team do. They educate, investigate, and advocate just like you do. Their work, however, tends to be characterized differently. For instance, P&As monitor for abuse and neglect. They advocate by negotiating, conducting mediation, alternative dispute resolution, and litigation. While some believe that much of the P&As do is litigate, only about 2% of their work is actually litigation. They also refer clients to other agencies as appropriate. The P&As need to be independent, and we know that some of the discussions about P&As center on some of what is on this slide. They really need to be independent in order to pursue legal and other appropriate measures on behalf of the clients. In addition, they must have access to those they support, as well as records and institutions. They also have the authority to conduct all aspects of their work. So while it appears restrictive, we see this as an opportunity to collaborate in the area of access. And a little bit lower down, I will provide you with some more opportunities to collaborate. Another one of our programs that we mentioned earlier, one of the ones that we administer here at ACL, is the PAT program, and it assists where we assist individuals of all ages with disabilities in the acquisition, utilization, or maintenance of assistive technology services or devices. The P&As provide information, advocacy, representation, training, technical assistance, and general guidance to increase access to and provision of AT devices and services. And as you know, we strive to support individuals with disabilities in every area that we are deemed to. or can. And this just happens to be a comprehensive view of the PAT program and what they do in the different states and territories. The PAT-B, this one was created in 2002 and to provide protection and advocacy services to individuals with traumatic brain injury. And this came to us a few years ago, actually, and it is part of our CBI grant network. So what we are striving to do is to collaborate as the best we can with those that are like-minded. And since ACL has two different CBI programs, one with the state network and one with the P&As, we strive to collaborate so that we can be more impactful in that area. We also have the Help America Vote Act, and this came to us in 2000, once it was enacted in 2002, came to us in 2003, and we administer Section 291, which relates just to the P&As, where awards are provided to 55 P&As, excluding the CNMI and the Native American Consortium, because it was started dealing with the general election, and because those two do not directly relate to the general elections every 4 years, then we didn't, they weren't funded, so they haven't been. 7% of the funds for PAVA are used for the training and technical assistance to the P&As, and as you will notice a little bit later, that training and technical assistance is provided through their national association, which is the National Disability Rights Network, which ensures that the P&As provide all of the services and supports associated with the Help America Vote Act. There are 7 mandated areas for the P&As under HAVA, and they are to ensure full participation in the electoral process for individuals with disabilities, so disabilities writ large, to provide education, training, and assistance as well, to participate in advocacy and education efforts revolving around HAVA. They provide training and technical assistance. They assist individuals with disabilities in filing complaints under state-based administrative grievance procedures, provide assistance to the states as well and other governmental entities, and obtain training and technical assistance on voting issues. So while on some level, some of the programs that we administer tend to focus only on individuals with disabilities, at the end of the day, it's really about supporting individuals with disabilities. Under the HAVA program, we choose to collaborate with state agencies as well. So individuals with disabilities are supported first. We look into whatever complaints they have, ensure that everyone has access to all of the voting machines that are available and ways of getting to the polling stations. We also train, the P&As can train those that work at the polling stations as well as individuals within the state agencies. There is another link that we included within this PowerPoint, and it is actually 16 minutes long. So what we encourage you to do is to view it at your leisure to provide you with some insight into how the P&As are conducting their work. Every year, the Protection and Advocacy Systems provide us with reports on exactly what they are doing. There are some reporting measures that we have to ensure that they are operating in the manner in which they should. And they provide us with reports on various areas such as their performance measures, which include the individual clients. And we are showing you just an example of the many pieces that we receive. And this relates to fiscal year 2017, where you can see the information and referral services that are offered, as well as individual clients served by the P&As. And you can also see the different trends, because we monitor the trends that the P&As, based on the activities that the P&As are undertaking, we monitor those trends to see if we need to provide targeted technical assistance to them, or if there's anything that we need to focus on. We also are interested in the intervention strategies that they use in serving individuals. You will notice some of these things are familiar to you as well in your work, where they do limited advocacy as well as administrative remedies. They conduct different negotiation techniques, and you see litigation from 2017 was actually only 3% of what they did. And then there's also the individual investigations that are conducted. There are some problem areas and complaints that clients, we either find out through an investigation or find out based on other people coming to the P&As to state these are some of the problem areas. And education is the largest across every P&A based on the clients served, and they tend to serve, most of the clients tend to be students within the public school system. There are also some concerns relating to home and community-based services, as well as healthcare. We also track the reasons for closing individual cases, and we have conversations with our P&As if we find any outliers relating to whether the cases have been closed, whether they have been these have been done successfully or not. The same relates to the group cases that are concluded, as well as advocacy services and individual investigations of abuse and neglect, where our largest cases relate to the findings of investigation and of abuse and neglect. Now, this is where we believe that there is an opportunity for you to collaborate with the P&As in your state or territory. The P&As are supposed to conduct planning sessions where it is basically data-driven. They conduct strategic planning. They do annual updates. One of the things that they do, they provide an annual opportunity for the public to comment on goals and priorities. And if any of you have ever partnered with the P&As, you will note that they normally publish that they are going to conduct they will either say hearings, or they will do public comment periods. And there are different ways of doing so. Sometimes they will do it in a setting that is centralized within their state or territory. They can also receive public comments in written format via email, or a mechanism via polling on their website. So they have different ways of doing their public comments, because this is how they determine what areas that they should focus on each year. And you will know, just like everyone else, there is limited funding for anything that we would like to do. And so they have to target the areas that they would like to focus on. And in doing so, they collaborate with different entities on exactly how to do so. And we find our P&As part of different collaborative efforts. Some of them are with our DD network partners, like Jennifer mentioned, the Council on Developmental Disabilities, as well as the University Centers for Excellence in Developmental Disabilities. They sit on each other's boards of council, and they provide feedback to each other on the areas that are the pressing and emerging needs of individuals with disabilities in their state. They also have good representation across the state. Their boards and councils have to basically look like the state. So if you have particular needs in the western side of the state, and there are some needs in the eastern side of the state, those should actually be communicated within the conversations with the P&As. Those that are not at the table on a regular basis, they are provided with the opportunity during this planning process of the goal setting, the goals and priority setting. What we found is that some of our P&As are proactive in reaching out to adult protective services. And there are just some natural partnerships, and some will take a bit getting into. Just wanted to provide you with a couple of examples on how some of the P&As have partnered. For instance, the Hawaii P&A stated that when they investigate allegations of abuse or neglect, they consult with APS to see if they have had an involvement. They also coordinate with them and the Long-Term Care Ombudsman Office on an ongoing basis. In North Dakota, both the P&A and APS have worked on a committee to identify proactive supports that can be put in place to support community living. In some instances, discussion may be used to prevent placement and movement to the North Dakota State Hospital or other more restrictive settings. Also, in Washington State, the P&A works for system change to address the failures in the abuse and neglect response systems, investigative functions with a focus on the Division of Social and Health Services, which is actually the Adult Protective Services and Residential Care Services area, and the Department of Health. They are focused on improving the state's abuse and neglect response system by improving the quality of investigations and protective services for victims during and after investigations. They also meet regularly as a team. So you will notice that there are some opportunities, natural, and some that they have to seek. And so we are encouraging you to do the same while we speak with the P&As and encourage them to do as well. In the priority setting, there are some areas that I needed to follow up on relating to where you may even think you may fit as a professional, as an advocate, as someone who is simply interested in this area. They tend to focus on employment, which I mentioned, housing, early intervention, and education. Education was the highest with the P&As. Safety, health, childcare, recreation, transportation, quality assurance, and formal and informal community support. So as you can see, these are broad. So there are many areas of emphasis that, that lend themselves to opportunities to be able to collaborate on. The P&As, based on how they are supposed to report to us, they are supposed to emphasize on outcomes and the type of impact that they are making within their community. And we are recommending that they collaborate because we all know that when you have more than one voice, you know, around the table, you tend to do more. So one of the requirements within the DD Act is that the DD network collaborates with community organizations. And so we are encouraging you to collaborate with them while we encourage them to collaborate with you so that you all can, everybody can be impactful within your particular state. I mentioned the reporting requirements a minute ago, and so we are fine here. I'm sure everyone also knows that with any time that you have a grant or a contract, there are reporting requirements, and with us, the P&As are required to do so on an annual basis. They are supposed to report on the progress made in carrying out the activities of the system, as well as achieving outcomes in terms of individuals with DD and their families, having access to the needed community services, support, and other forms of assistance. Like some of the charts showed, these are the things that we get as a result of they providing reports to us. Each P&A statute authorizes funding for training and technical assistance for PAD, PAT, and PAT-B. It is provided under the contract with the Training and Advocacy Support Center at the National Disability Rights Network. And any of you who is familiar with NDRN will note that every year they conduct an annual meeting, and most recently it was in June in Baltimore, Maryland. And it allowed persons, not simply from the P&As, but anyone interested in our work to be able to understand what we do and how we can best do things or conduct our activities better in support of individuals with disabilities. This contract is funded through an interagency agreement with SAMHSA and the Department of Education, and we are the lead on that particular contract. So we are collaborating at the federal level as well. For the Help America Vote Act, the funding for this training and technical assistance is through grants with the Federation of the Blind, National Federation of the Blind, as well as the National Disability Rights Network. Their grants was set to expire as of next month. They will be extended for another year as well. We are leaving our website information links on here for you, so you can peruse the ACL website just to, and if there are any questions that come up after you have reviewed the website, you can certainly ask us those questions. We try to rush through almost this presentation so that the bulk of the time is provided for you to ask any questions that you have of us. And again, like Jennifer said, if we cannot get to all of the questions, while I am at the conference in 2 weeks, there will be opportunity to either answer them or for you to ask even more questions. So I'm going to turn it back to you, Andrew.
Thank you, Ophelia, and I'll actually turn it over to Lori Del Grammaticus to do our question and answer section.
Okay, so everyone, this is your opportunity to pose questions in the question box. So far, we only have a comment that came in during the introductions of all your credentials, which effectively said, "Wow, you know, you have some really deep backgrounds." I will ask a question. When a P&A asks APS for their records, how are those records used once you get them?
And thank you for asking that, Lori. In the P&A's effort to investigate abuse, neglect, they have to be able to go through the records, interview certain persons, including the affected individuals, if appropriate, and in order to formulate their case to determine whether they need to move forward with any type of action. So those are used internally within their particular team if there's anything else that is needed in terms of making a case or citing any kind of neglect, abuse, this is what it is used for. It is unclear maybe what people assume P&As use the records for. Do you have any example, for instance, Lori, as to whether, or Jennifer can go ahead?
Yeah, if I could also add, I think there was a slide where we made reference to the authority of the
Yes.
P&A.
Yes.
And there it was. So the DD Act has specific language in it around the P&A authority, which is the authority to pursue legal remedies and to investigate incidences of abuse and neglect. So that's an important authority for them to have so that they can use what means they feel is necessary or what is appropriate in order to remedy any cases of a civil rights violation, which could include abuse or neglect. Related to that authority is the authority to have access to people and access to records and access to institutions for monitoring. So these are two key pieces of language within the DD Act for the P&A program so that they can do the work that they do. And yeah, they will access a variety of records. They will access a variety of settings. And as Ophelia said, it's really to verify any allegations of abuse, neglect, or other types of civil rights violations. And that's obviously needed in order to substantiate whether the abuse or neglect or civil rights violation has occurred. In addition to what Ophelia said, I would just add that P&As do follow rules of confidentiality. Mm-hmm. So any information that they access related to any case they're investigating or any case in which they're representing an individual where they have asked for information from another entity, again, they have to follow all protocols of confidentiality where information is not shared, and again, it's used to substantiate whether the allegation is valid or not.
Absolutely. And whenever you get onto the ACL website, one of the first things you'll see at the top is reference to the DD Act. If you go into section 143, you will find the same information that Jennifer just mentioned, relating to independence, access, and the authority of the P&As.
Okay, so one of the things I've heard APS programs worry about is getting sued by you guys.
Okay.
You know, and how does that work, and how would that be related to the records you receive and when you get those records?
I think something to note is that what we mentioned earlier was that litigation is very low in terms of priority, if that, of the P&As. It is something that the P&As would seek to do as almost last resort. The P&As are really trying to mitigate any kind of any issues, and one of their priorities is to do so without litigation. I do not believe that the APS teams should fear that the P&As would sue them and prevent them from collaborating with the P&As. You can certainly do more if you partner with them than being, concerned about being sued. I think one of the things that we may need to note, and that is overall, not just with this population, but communication is really the key. If you find that you are conducting ongoing conversations, discussions with the P&As, you all are collaborating on different committees, etc. If there is a red flag, the P&As would bring it to your attention, just like you would provide some information to them. So I wouldn't see that as being a huge issue, And it is rather unfortunate that this is what many people are focusing on.
Yeah, I would have to agree with you. This is Lori. But I do know that we often get legal opinions around whether state confidentiality rules override what the P&As are allowed to have under federal guidelines, and I believe that's a place where we all need more clarification. Because you're right, if we can work, we have APS and the P&As have a similar mission and realistically should be working together. Do you have some examples of places where you think the P&As and APS are working well together?
Yes, the states that I mentioned, we also have a notable collaborative activity in California, but I also mentioned Hawaii, Washington, and North Dakota. Georgia is doing quite a bit. Between APS and the P&A. So yes, we do have some notable areas. Mm-hmm.
And Lori, this is Jennifer, just going back to the earlier comment about needing clarity around the access authority that P&As have. That is the area where we do get the most questions about the P&A program. And we do have a lot of detailed information, not only in the law, but in our regulations around the access authority of P&As. But we oftentimes have states coming to us with questions related to whether they would have the authority to access the records that they might be trying to access. And there is a number of case laws around their access authority that is quite useful in helping to understand how the access authority pretty much prevails in all situations. There hasn't been a case that's been before a court where the P&A access authority has been denied. So it is pretty broad, but yes, an area where there are a lot of questions, and rightfully so, because we are dealing with individuals who are likely in unfortunate circumstances if they're being abused or neglected, and we want to make sure that we're being as careful as possible with their information.
Totally. I'm not seeing yet any questions from the audience.
Actually, Lori, we've got a few. Maybe they're not popping up on your screen. I can.
There we go. Yep. Let me see if I can make this larger so I can read it. That seems to be what the problem is.
Why don't I go ahead and do the first one while you're looking at that, Lori?
Okay.
And this is for both you, Ophelia and Jennifer. Do P&As have any obligation to share information about abuse neglect investigations with state adult protective service agencies? And I'll repeat that. Do P&As have any obligation to share information about abuse neglect investigations with state APS agencies?
In short, no.
Thank you. Let's see, let me move on to the next one. I know that protection and advocacy organizations can obtain APS investigations in some states. Does the P&A share their investigations? I guess that's a pretty similar question to what we had before, but are there occasions where the P&A agencies can share their information with APS?
I think what more often will happen with a P&A is they will share reports from their investigations, so they're not identifying individuals within the reports. So examples of that would be reports that they do on their monitoring in institutions or in group homes, and where they report those findings. Sometimes they might report them to the public, sometimes it might be to that institution. As an example, not related to adult protective services, but recently the Florida P&A did a monitoring visit of a facility for the unaccompanied alien children within the Office of Refugee Resettlement shelter facility, and they did a public report on what they found there. And so it was an investigation of that facility, and they did a public report, but I don't think there would be circumstances under which they would share reports about individuals and the investigations related to those individuals because of the confidentiality requirements.
Yes.
Okay, so how has the reorganization of ACL changed reporting requirements of the PAD program?
It has not, actually. Some of the same individuals that have been overseeing the P&As are still doing so. So the reporting requirements continue to be the same.
Okay.
Thank you.
Do P&As have access authority in community settings?
Yes, they do.
Okay. Can you describe the approval process for bringing PAD lawsuits? Does ACL approve PAD litigation?
We do not. It's almost, and I think I explained it to someone who called some time ago, it's almost like getting on a moving train. And we cannot certainly get in on something that's already in process. So no, we provide the authority to them through the DD Act. Therefore, they undertake those with the best intent.
I would add to that the merits of it, we cannot determine the merits of a case. Obviously, there would be intensive resources that would be necessary for us to determine the merits of individual or group cases that a P&A takes on. So that is one consideration. But again, we're not, a legal entity to determine the merits of a case. And if there are any questions about a case, it will be brought to court. And most often, any questions about the merit of a case is not found in either a court or the case goes to settlement before going to court. So I know we do get questions about that and the merits of cases, but we do not have a role in that because, again, we're not the entity to determine the merits of a case.
Got it. Okay. Another one, our state's PAD has openly called for the closure of all in-state facilities licenses, ICFs and IIDs. What would you say to families who find their state's PAD is thus unwilling to assist an individual asserting their congressionally granted rights to ICF residential service when you've just said that the P&A protect and advocate, advocate the legal and human rights of individuals with developmental disabilities?
So I'm going to, maybe I can. That's a good question and a good point of clarification. Under the DD Act, the requirement for all of our programs are to work towards, and actually, not only people having control over their lives and contributing in their community, but also the right to live in the community in terms of being included and integrated, and that being in the community where people without disabilities, all other Americans are living. That said, P&As do work in institutional type settings where they do monitor for abuse and neglect to ensure that people are safe from abuse and neglect. And there are a number of circumstances in which they have found abuse and neglect occurring in institutional settings, and they work with that institution to ensure that they are working towards the health and safety of that individual, and if they are utilizing any abusive practices, that they work with them to end those. But again, the principles of the DD Act is that our programs are working towards people living in the community where all other Americans are living. So that is going to be an important part of their work.
Okay. We have a number of questions around, do P&As share their information and their investigations back to APS at all? Is that something that can happen?
I think, like Jennifer mentioned, they provide reports to others after they have conducted their investigations.
Is that done routinely, or is that something APS would have to request, or how does that work?
I think it is not done routinely because the relationship is different in every state.
Sure.
So I think they could certainly request and see if that particular P&A will provide it. Yeah, it is not done routinely.
Okay. Okay, this is an interesting one. What do people do if their P&A is hostile to their rights? I'm not sure how that's meant.
Yes, we are not sure either, because one of the things that we want to remind everyone is the reason for having a P&A to begin with. And we do not see P&As as being hostile, and since there are 57 of them, we are not really sure which they are referring to and, you know, where the hostility may be coming from. Because they are basically supposed to be working to resolve complaints through mediation, and they are supposed to investigate and, you know, provide information and referrals and monitoring activities. So we are not sure of that question.
Okay. Yeah, I'm not sure either. They're coming in fast, and we may have to forward this list of questions to you if we might.
Okay.
Because I think there's more than we're going to get to today.
Okay.
I will do this last one. Would you briefly characterize the P&A's collaboration with the Ombudsman program?
So that would be the long-term care ombudsman program?
Yes, I believe that's what they're referring to.
So I think it's similar to what we see in terms of their collaboration with the with the Adult Protective Services System. That's going to vary in each state and territory, the way in which and the extent to which they collaborate. There are great examples of ways in which the long-term care ombudsman collaborate with the P&A and vice versa. You know, we think there's a lot of opportunities there as well for collaboration. And we run into some of the same issues around access, authority, and the sharing of records because of some of the language in the Older Americans Act around the long-term care ombudsman program and the requirements they have to follow in terms of confidentiality. So a lot of similarities, and we are working with them as well in terms of our collaboration with that program in the state and territories.
All right. Well, I think we're going to close with that. I want to thank you so much for being willing to come on and talk to APS folks in general. I hope that this is the start of much more collaboration and working together to clarify what each of us do and how we can work together. Ophelia, I'm really glad that you're going to be at the NAPSA conference in 2 weeks in person so that more of our APS folks can ask you questions in person. They will love that, I know. And Andy, we can work on sending this list of questions out to our speakers so that they can answer whatever questions we didn't get to. Is that correct?
Certainly, yes.
All right. So thank you so much, and we certainly appreciate your time. Thank you to the audience for showing up and showing an interest in this area. I think we have lots of work to do to work together going forward. So have a great day. Thank you, Andy.
Thank you.
Thank you.
Thank you, everybody.